Now, this is not a difficult chapter. This is very simple. The status of illegal contracts. So we've already talked about this, so we're just going to go through this quickly, make sure you're all comfortable with the concepts involved. Basically, if it's illegal, it's illegal, and the courts are not going to enforce it. Now, classic example, you know, many of us have gone to Super Bowl parties. A lot of Super Bowl parties, they've got a pool sitting there, and they do it by quarters and scores and all sorts of complicated schemes. So you go to a Super Bowl party, and you put your $5 or $10 into the kitty and write your numbers down or whatever. End of the night, you're the winner. So you're all excited. You're going to get $500 because it was a big party, a lot of people there. The person has absconded with the $500. It's gone. And you're not even sure who it was because it was a big party, you know, friends and friends invited you. Even if you knew who took the money, you cannot sue them because that is an illegal gambling enterprise. So since it was illegal, there's no legal action. I can't suggest how you might approach getting the money, but it won't be fun. Talk about that the moral obligation part. If you owe me the money, but may not be the thing. Generally speaking, what the courts are going to, I'm sorry, go ahead.
What if it's the opposite? And I'm just like if something becomes illegal, becomes legal.
Well, in our modern society, unfortunately, that doesn't happen very often. Well, I'll tell you where it does happen, in fairness. The question is, suppose something that was illegal becomes legal, marijuana. So marijuana, I know Massachusetts, I was in Boston a couple weeks ago for a family event. Massachusetts is going to vote on legalizing marijuana, I think, in the November 8th election. So all the potheads will show up to vote, so whatever that is. And so what happens is that if it becomes legal, which a lot of things don't, but that's a good example of something that might here in the United States, is it would validate contracts. So if you entered into a contract now saying, I think marijuana will become legal, so therefore I'm going to contract to build a greenhouse to manufacture, you know, marijuana, you might be able to turn it into a valid contract if the vote passes. You're already ready to cook up some marijuana. But generally speaking, it usually goes the other direction, as our example earlier about spice, where it became illegal afterwards.
Now, in regards to the spice example you gave, something becoming illegal in your state,
yes.
Well, you can't sell it back to where it came from, because that would be illegal. Can you do some type of trade to get something in return?
I think what you would have is rescission, where the court would basically say, you send the spice back and you get your money back. Now, what makes it complicated on purpose, by the way, in that example, is the spice came from West Virginia. West Virginia was still legal to manufacture in West Virginia. So they might argue, if the contract was not clear that it was still legal in West Virginia, still an enforceable contract, it wasn't their problem that you were trying to sell it in Virginia. The purpose of the exercise is choice of laws provision. And remember, we talked about that with the Oklahoma purchase order, is that the purchase order from my side says enforceable in Houston, Texas. Much safer to have a well-written contract, and when we enter into contracts on our clients here in Houston, Texas, they all say enforceable in Houston, Harris County, Texas. So we handle it by a choice of laws provision. But again, in our spice example, that may not have been in those contracts.
Now, shifting forward to the illegal contracts, say like the website DraftKings or the other sporting...
Yes, the national or international gambling sites. It's fascinating because they're doing television commercials, but supposedly they're illegal. I don't know how to explain that. Yeah, because I don't understand how you can run national television commercials for an illegal enterprise.
A winner on that website?
Yeah.
Well, if you were declared a winner, but you didn't receive any type of, your winnings,
yeah.
Could you sue DraftKings still, or that?
Not if it's an illegal enterprise. Unless you could show that they represented that they had somehow made it legal and that you were justifiably relied on it, their representation that it was legal. I don't see, I've seen a handful of those TV commercials, and I don't see anywhere they say it's legal in your state, or where it says it's only legal where gambling is legal. Because even if you were to do this in Las Vegas, you know, the home of legal gambling, it is very, very heavily regulated. It would not allow something like this because, you know, after all, it's all about money. So that money is not coming into the city or state of Nevada. It's actually the state of Nevada regulates the gambling industry there, as it does in the states like New Jersey and Louisiana that have legalized big gambling. Those are state laws that are in place. If it's not authorized under state law, it's just as easy. So again, I can't really address it because I don't know all the pieces, but I was very surprised because it looked like all of that had been shut down, and then all of a sudden they started doing TV commercials again. So I'm not sure how they're getting around it. But I wouldn't bet on collecting your money if it doesn't show up. Yeah, and you know, they may be giving you points or something other than real money, which would not be fun. We had talked about a lot of this stuff. If it's fraud or duress to enter into the agreement, and it turns out it's an illegal agreement, then you can certainly look at it from that standpoint. And that's what we're talking about, perhaps, on these illegal gambling sites, is that it looks like, because they're on national TV channels, raising the issue about whether you could arguably sue some of the cable channels and say, you're taking advertising, which gives us a sense of legitimacy. That's the scuzzy argument. I wouldn't like that one, but that's something from a trade commission might do on behalf of the public. But I don't think you want to handle that as an individual. I think that's a high burden to overcome. Now, we talked about statutes. We're going to get past that. Let's talk briefly about licensing. Very famous case here in Houston. Had a dentist who came here from Mexico, opened up shop in the barrios, and he is doing all sorts of things going on, and eventually one of the people has a real bad toothache that didn't get fixed at the illegal dentist, go to a real dentist, and he looks at it and he says, we don't do this the way that it looks like this in the United States. We do it differently here. The person clearly wasn't trained in the United States. So immediately...
So, I'm sorry.
Go ahead.
But, so the dentist had to go through like some sort of certification here?
Oh, he didn't do it. He didn't do anything. Oh, no. He didn't do anything. He just opened up shop in a place where he figured nobody was really watching. And he did hundreds of people. Generally speaking, people were not that unhappy because they were paying cheap and it was working for them. But this one individual goes in because they're really having some serious problems. And what happens is that the dentist, the American dentist who looks at it says, this is not done by an American dentist. We're not sure who did this, but it's definitely not done by someone trained and licensed in the United States. So it's that broad an observation. Calls the licensing authorities, they go and they arrest this guy. And it's a criminal offense for pretending to be a dentist. Now again, he could be a dentist in whatever country he trained in, but you have to be a licensed dentist in Texas in order to provide dental services here. This is across the board. Big prosecution in Texas is for the unauthorized practice of law. In fact, I turned in a lawyer for UPL about 6 or 8 months ago, and I found out not only is there a state bar committee for unauthorized practice of law, they have 2 committees in Harris County by itself under the auspices of the state bar. That's how big a problem it is. So a lot of stuff going on. It is a criminal offense as well as a civil offense to practice without the proper licensure. Now I want to mention at this point one particular area. We talk about real estate contracts, very serious area. Biggest purchase for most people is their home. You need to have writing on the statute of frauds to document your transaction. There's a lot of important pieces here. How about real estate commissions? State law in Texas, to get a commission, you must be a licensed real estate broker and you must have a written fee agreement. No cut deal. And you heard I said broker. What about a salesperson? The salesperson may be directly involved in the deal. They operate under their broker. The sales commission can only go to the broker, and then it is between the broker and the salesperson how much the salesperson gets. Now, in the old days, it used to be 50-50. The broker got 50%, the salesperson did. I see you shaking your head. Tell me what you think. Go ahead.
No, my dad's a real estate agent. So
Go ahead.
I want to say it's like 6% or something.
Well, no, that's the total sale of the house, is 6%. But what we're talking about is the split between the broker and the salesperson reporting through that broker. Is your dad a broker or a salesperson?
He's a broker now. He was a sales broker.
He's been a broker for, he's been a salesperson for a while.
Yeah.
Okay. So what happens is the commission can only be paid to a broker. So if the salesperson actually does the sale, it's going to be between them and their broker, the percentage. Used to be 50-50 between broker and salesperson. That's gone today. A lot of times the real estate agent pays a fixed fee towards the overhead of the office and then keeps a much larger percentage of the commission. And there are all sorts of deals today. But the other part of that deal is the commission sale. We're going to come back and talk about that famous 6% commission on sales of real estate, because that is a much hated number by the Federal Trade Commission. We're going to come back and talk about that. Thanks for bringing that up. We're going to definitely visit some more on that. Now, usury. We just want you to know what the word usury means, folks. Usury used to be a big deal. Usury is loaning money for more than the legal limited interest rate. Texas famously had a usury law. What happened about 30 years ago, almost exactly, the United States experienced runaway inflation. Mortgage rates shot up to almost 20%. Imagine a 20% mortgage. It's almost unthinkable. And I had a 13.5% mortgage during that time. And I was considered lucky. Well, imagine what that looks like today. We're paying 3.5% and 3.75% home interest rates. Yeah, so big difference. But anyway, when the runaway inflation hit, you couldn't borrow money in Texas because you hit the usury limit, the limit on how much you could charge and interest you could charge. So Texas had to modify its laws, so Texas is pretty much the same. And one of the things that's a result of the state usury laws is that if you've ever read your credit card contracts, they're enforceable in South Dakota. They pick a state that has no limitation on interest, and your contract with your credit card company says it's enforceable in South Dakota, and South Dakota, you agree to South Dakota law applies. So that's how they get around some of the state usury laws. So a key element here is the term usury means that there's a state limit, is exceeding the state limit. If they do that, in some states, the penalty is you can charge no interest. So you sue and the court says, oh, you exceeded the state limit, no interest. You can recover your principal, but not the interest. So, but again, these laws have largely been modified or taken out of effect because of runaway inflation in the past.
How does it apply to payday loans?
Oh, payday loans, one of my favorite subjects.
Or isn't that basically what?
Yeah, but it's because the usury laws came off, so the payday loan companies operate under, because if the usury laws were still here, you couldn't do payday loans because the interest rates are ludicrous. And payday loans are just legalized money shark. I mean, you know, what the mob used to run. So basically, the state has replaced the mob. So the state runs the lottery, which is a numbers game. You have almost no chance of winning. About the only advantage you have is if you actually, by some literal miracle, win, you're probably reasonably sure of getting the money. The state runs the lottery. But it's really just numbers game, as you've heard about in gangster movies and mob movies and stuff. Loans are the same thing. You know, you went to your local guy and you said, hey, I need $100 until payday, and he'd say, okay, on payday you give me $200. Ludicrous amount of interest. Payday loans, not much better, but they're out there. But yeah, they operate either under specific legal standards or they operate underneath the usury laws if they still exist in different states. Yes, sir?
As I understand how the law is written, it's
Yeah.
still in place at 18% in the state of
Yeah.
Texas. How the payday loan places have gotten around it is that they're, instead of charging an interest, they're charging a fee.
Front fee.
Yeah, it's an upfront fee, and so when you do the math and you come up with these 1,000% interest rates, which is the reality of what's going on, but because of the way it's stated and they get a bunch of good lawyers in there to put it together, it slides into the usury law.
And there's a lot of criticism of payday laws. There are some regulations specifically, like I think you're restricted from rolling a payday loan now, which was the biggest problem, is people never got out, but it doesn't really help the person because your payday loan on this corner can't roll it. They just go to the payday loan on the next corner and they roll yours onto theirs, and they're allowed to do that. They just can't roll it within the same payday loan company. So I don't know how that helps consumers, but it is definitely an area of concern to consumers. Agreements and restated trade, we mentioned this before, is we've got the antitrust laws. Probably one of the most criticized standards under the law is the 6% real estate commission. Now what was interesting is we had a very hot real estate market, some of you may remember from 10 or 12 years ago, before the subprime meltdown, and we began to have a lot of competition in rates. People would advertise 4%, 4.5%, 1%, and 3% to the selling agent, and so forth. Most of that has pretty much gone away. I've noticed that, pretty much since the crash, even though Houston didn't take the crash as bad as most of the country, I don't know if you realize that, Houston took a crash and it's like a little like this. In Virginia it was this. Still, the prices in Virginia, other than the Washington, D.C. area, are still well below where they were in 2006 and 2007. Very, very tough conditions around the country. So in any event, a lot of it depends on, that commission, but today it seems like that 6% is pretty solid, across the country. Might be more competition in the hotter market. Now keep in mind, if you're over in Bel Air or River Oaks and you're selling multi-million-dollar houses, those are all, generally speaking, going to be negotiated commissions. What we're talking about is generally houses under $500,000 or $600,000. You pretty much don't have a lot of market leverage to negotiate. And I know it sounds unfair, and if you're talking $500,000 house, 6% commission is $30,000. Agreed. But here's the problem with that. It's generally split 4 ways. The selling agent and broker get 3% and all that, so you're down to $15,000. Then the salesperson and the broker on each side split it, and under the old days it'd be $7,500 and $7,500. Today it's more likely $9,000 or $10,000 to the selling agent, the difference to the broker. So you have a lot of different factors at play, but again, the feds are very convinced that it's a huge conspiracy to fix prices. So people need to be aware of that and need to be careful. Horizontal price fixing, you can't agree with your fellow gas stations. One of our best examples right here on the corner with the 2 brand new gas stations across the street from each other, competing to have some of the highest gasoline prices in town. See, I see people with their cars in those gas stations all the time, and I'm like, you can't drive 2 blocks to save 25 cents a gallon? And it's not my fight to do, but anyway, people cannot collude to fix prices. Now, what about public policy? And this can be stuff like that you agree that you won't report people for fraud, or you won't, do things that are improper, gambling, prostitution, things like that. God bless you. That are parts of public policy, okay? So let's keep that in mind. Now, agreements not to compete. Very controversial area, and I touched on this briefly earlier tonight. And by the way, I was quoted, if you look at my LinkedIn page, I just posted up on it. I'm part of the speakers committee here for the University of St. Thomas, and was interviewed for an article on non-compete agreements for medical doctors. So if you go to my LinkedIn page, you'll see a Actually, you'll see a link to the article itself. But one of the things to appreciate is Texas is in the middle. Again, Virginia non-competes are very enforceable. Here in Texas, difficult but enforceable. California can't even be they're barred by state law. So be aware of, again, if you're in a multi-state situation, you're in a business that operates as many businesses do across state lines, that you have to comply with the different states. California is very aggressive. If you have people going into that state to work, even if they're based in Houston, they may allege that you can't enforce them. So you have to really be careful dealing with California for what it's worth. Now, we talked about unconscionability. Here's the word. Everybody together, unconscionability. Okay. Again, it is a standard under the Texas Deceptive Trade Practices Act. As business people, we are rarely going to be able to allege this. About the only example I can think of is if there is a big storm and there's price gouging where people charge $10 a gallon for gasoline and $10 for a gallon of water, drinking water and stuff like that. However, most states have disaster provisions that they're usually called price gouging statutes that say in the event of a national emergency, if you do that, it's a criminal offense. Again, more push towards making things not just civilly wrong, but criminal offenses. And it was interesting because I remember during a storm a couple of years ago, there was a gas station that charged $5 or $6 for gasoline. And they were on the news, and they said, we don't really care. This is what we choose to charge and all that. So I don't know if they were getting legal counsel that said that they could say that and get away with it or not, because I guess literally you can charge any price you want for anything, unless there's price controls. But I think if they went from charging $3 a gallon to $7 a gallon overnight during an emergency, I don't think they'd get very far with the public authorities in terms of enforcing that. So keep that in mind. But again, we're allowed to allege this as consumers, hard as business people. Now, contracts of adhesion, this is very simply illustrated by the famous clause from The Godfather. What's the famous clause? No takers? Everybody?
They can't refuse?
Yeah! Very
Okay,
good.
all right.
Make him an offer he can't refuse. That's a contract of adhesion. So when people are really under the gun, and that may also be our situation of price gouging. There's been a storm. There's a real shortage of building materials, tarps, water. And you say, if you want this, you've got to buy 60 of them because, we've got plenty of people to buy them. You have to belly up to the bar and take whatever we're distributing and buy some of this other stuff and whatever. So watch out for that because, again, it may seem like you're being a great business person. You may be being too good a business person. It may cause some problems. So you need to watch out for that. Disclaimers of liability, I spend a lot of time in this area. Watch out here in Texas because a lot of big oil companies operate here, some of the biggest companies in the world. And they then do business with a lot of small companies, including some of the companies I consult for. So what happens is the big oil companies send out this contract that says, if anything ever happens in this deal, it's your fault. Even if it's our fault, it's your fault. Now, the problem with this is that it creates a very unfair bargaining position because the little guys really need the work. And there are a lot of little guys, so if they say, I'm not willing to agree to this contract, they go to the guy next door, maybe the guy doesn't have an attorney reading the contract or doesn't bother reading it himself, agrees to these very unfair liability provisions, okay? So one of the things I want you to think about is that because of this, Texas has passed an oil field protection law and several other laws that prohibit putting all of the liability on the contractor. But it's very specific to certain parts of the oil industry. It's not across the board. Again, as business people, you are responsible for understanding the contracts you entered into. Many, many contracts, especially bigger to little, and I work with a lot of little guys, is that you're responsible. You're stuck. And the best thing I can tell you is, number one, try to negotiate. And we do have success negotiating down to what we call reciprocal indemnity. We'll take care of ours, you take care of yours. So, and that does happen. The other thing is communicating with your insurance company to say, we're being asked to sign this contract, what are our liabilities, and are you insuring us for all these liabilities, making sure you have insurance. There's a corollary to that last point. Your insurance company comes back and says, this is a lot of liability. So for this $200,000 contract, your insurance is going to go up $10,000. So you go to the big oil company and you say, we will do this deal for our contract price plus $10,000 because we're going to need to buy that additional insurance. Back when I was in-house to oil companies, we began seeing that, and it's a long time ago, but I was in-house, is we began to negotiate better deals with our contractors because our insurance cost was much cheaper than their cost. Basically, big companies are wholesale, little companies pay retail for insurance. So it creates exactly the wrong effect. In other words, the big company actually can afford what the little guy can't, but if the little guy goes back and says, I have to pay all this retail cost for insurance, all you have to do is absorb your own responsibility and I can save $10,000. A lot of the companies will come around and say, well, let's talk about it. And a number of companies have implemented what they call a small vendor solution. Usually vendors in contracts less than $500,000. They'll allow them to enter into a different deal. And think about it, a lot of times those type of oppressive liability assignment contracts affect minority and female-owned businesses, what we call SWAMs. Small Women and Minority Businesses, SWAM. It's actually a technical term. We have certification here in Houston, Harris County for small businesses. A lot of those businesses can be basically put out of the contracting business. They can do business, they just can't do business with big companies because they can't afford the insurance. So if these companies want to have a more diversified supply pool, they're going to need to be careful. So again, but from a legal standpoint, depending on state law, many of these assignments of liability are binding here in Texas, but not across the board.
What do they call the type of contracts that they're doing for $500,000 and less contracts? Is there a term for that?
They will call it they'll call it a they don't usually call it minority business adjustment. Usually call it small business.
You can't put that on paper.
No, you can. You can do affirmative action on government contracts. You certainly can, but they usually call it small business set aside. And part of the package of small business set aside is often relief on the insurance provisions, so that they don't have to spend so much of the cost of the policy of the project on the insurance of itself. Folks, one other issue on disclaiming liability is the infamous ticket. You drive into a parking garage, you pull a ticket, you never read it. On your way out, you turn it in, you pay your money, and you leave. Everything's good, right? Your car's in the parking garage. A piece of the ceiling of the parking garage falls on your car. You are a very unhappy camper. Okay. Generally speaking, you may not be able to recover, though you might go after the company that built the parking garage. You might try some angles. Very difficult, because what has been created is a bailment. You have just holding the item. You're not taking responsibility for it. Now, in contrast, you have a valet park. Same card, same disclaimer liability, most likely not enforceable, because they are taking custody of your car, and if they damage your car, they will certainly be responsible for it, even if they do a disclaimer, but it's going to be a mess to do it. What we're seeing a lot with LA companies is that they allege that the damage didn't happen. that it wasn't your fault. And so basically, number one, we recommend people avoid valets at all costs. Two, if you must valet, walk your whole car before you take delivery. Yeah, but it's really unfortunate, a mess.